Here are your Court News Ohio top stories in 5 minutes.
The 31st state champion of Ohio high school mock trial is Sylvania Southview High School.
Sylvania Southview High School took home the trophy at the Ohio High School Mock Trial State Finals. In the competition at the Ohio State House, the Lucas County School went up against Orange High School from Pepper Pike in Cuyahoga County in a simulated trial before a panel of judges.
With all due respect to opposing counsel, the school is always the time. The school is always the place for this exchange of ideas.
Sylvania Southview senior Yuran Chen was named by the judges as the outstanding attorney for the final competition.
It feels good that we can represent our school this way. We've been working for, probably a couple hours a night per week. Every single day after school, we'd go to our coach's house and work. So this is just like a culmination of all of that work.
This is the 6th time a team from Sylvania Southview has won, but the first in 10 years. The 31st annual state final competition started with about 300 high school students from 30 teams across the state of Ohio. Ohio Mock Trial Program, a program of the Ohio Center for Law-Related Education, is Ohio's largest high school academic competition, with more than 3,500 students participating every year. Goals of the program include helping students to understand constitutional rights and responsibilities. This year's case analyzed student rights under the First and Fourth Amendments related to freedom of expression and unreasonable search and seizure. Sylvania Southview will represent Ohio at the National High School Mock Trial Championship this May in Madison, Wisconsin. There are more than 40,000 attorneys actively practicing law in Ohio, and an overwhelming majority of them observe high standards of integrity when it comes to handling their clients' money. For the 0.1% who do not, there's the Clients Security Fund of Ohio.
The Client Security Fund was established in 1985 by the Supreme Court of Ohio with the purpose of improving the image of the legal profession by reimbursing those law clients who have sustained losses of money or property as a result of their dishonest lawyer.
Client Security Fund Administrator Janet Green Marbley adds that the fund is supported entirely by attorney registration fees. For the past 28 years, more than $18 million have been reimbursed to victims of dishonest lawyers. In the latest quarterly release of funds, the Board of Commissioners of the Client Security Fund voted to reimburse 22 victims of attorney theft more than $100,000.
The majority of the claims that we investigate and that are reimbursed are what we call unearned fee claims. And those are situations where clients pay a fee to their lawyer for the services to be provided, and the lawyer fails to provide the services.
Clients who believe they have lost money because of attorney misconduct should contact the fund to file a claim.
The Ohio Supreme Court has ruled that Ohio's child enticement statute is unconstitutional. In the 5-2 decision on March 6th, authored by Justice Judith Ann Lanzinger, the judgments of both the 10th District Court of Appeals and the Franklin County Common Pleas Court were upheld because the broad language of the statute can lead to criminal charges against the person in many innocent situations. In the case before the court, a Columbus man was charged with criminal child enticement after allegedly offering money to a neighborhood child to carry some boxes to his apartment, an innocent request according to the man's attorney.
The statute criminalizes asking certain questions of a child, regardless of the questioner's motives, simply because the parents might disapprove.
Justice Lanzinger wrote, "The statute fails to require that the prohibited solicitation, coaxing, enticing, or luring occur with the intent to commit any unlawful act." She added that even if the court narrowly defined the word solicit in the statute, the law would still criminalize a substantial amount of activity protected by the First Amendment. Justice Judith French dissented in an opinion joined by Chief Justice Maureen O'Connor, and contended the court should interpret the term solicit narrowly instead of declaring the statute unconstitutional.
That's a look at Court News Ohio's top stories. Visit courtnewsohio.gov for the latest headlines on Ohio's courts. You can also follow us on Facebook and Twitter.